Doug Austin, and I'm the editor of eDiscovery Today, a daily blog about eDiscovery, information governance, cybersecurity, data privacy, and artificial intelligence trends, best practices, and case law. Welcome to another edition of eDiscovery Today's Thought Leader interview series, where we interview thought leaders in eDiscovery and related legal technologies. Today's guest is an eDiscovery expert who has so much experience, she literally wrote the book on eDiscovery best practices, Nicole Marie Gill of CODISCOVR. Welcome, Nicole.
Welcome. Thank you for having me.
I'm glad to have you and excited to talk to you. Before we get started, let me introduce Nicole. Chair and managing member of CoDiscover and ancillary business of Cozen O'Connor, Nicole works with attorneys and clients firm-wide to develop efficient and effective discovery management strategies tailored to the case at hand. Leveraging advanced technologies and analytics, she manages complex and high-profile eDiscovery projects and routinely navigates data and privacy protection laws across many jurisdictions, both domestic and foreign. Nicole participates in 26F conferences, negotiates agreements and stipulations, establishing parties' obligations with respect to preserving, searching, and producing electronically stored information, directs use of AI in discovery, and negotiates technology-assisted review and predictive coding protocols. She also advises on collection methodology, search and retrieval methodology, FRE 502D orders, and production specifications, and develops internal and external discovery guidelines addressing each phase of the electronic discovery reference model, aka EDRM. Additionally, Nicole is involved in discovery-related motion practice, including the drafting of affidavits in support of cost shifting. She also implements quality control procedures to mitigate risk and counsels both clients and colleagues on issues related to e-discovery, information governance, and data management. Nicole has written the ABA's book on eDiscovery best practices for eDiscovery, a practical handbook, which I featured in eDiscovery Today a few days ago. She's also a regular columnist for Thomson Reuters, where she addresses and navigates novel eDiscovery issues. She's a member of the Sedona Conference and is currently part of the WG6 drafting committee focused on exploring data privacy issues related to the exportation of data from the People's Republic of China. Nicole has written articles appearing in the Legal Intelligencer, Bloomberg Law, the Journal of the American Osteopathic Association, the Pennsylvania Bar Association Quarterly, and the World Association for Medical Law's Medicine and Law Journal. She's spoken on numerous eDiscovery related panels at the country's most reputable conferences, including Georgetown Law's Advanced eDiscovery Institute, the International Legal Technology Association's Evolve Conference, the Construction Super Conference, the Sedona Conference, the Masters Conference, the Association of Corporate Counsel's Annual Conference, and Law.com's Women, Influence, and Power in Law Conference. Nicole is also a member of the Philadelphia chapter of Women in eDiscovery, serves as co-chair of the Philadelphia Bar Association's Wellness and Quality of Life Committee, and is on the firm's Women's Initiative Executive Committee. Prior to joining the firm, Nicole was an associate attorney at the Philadelphia office of a Northeast-based law firm where she defended healthcare providers and companies in malpractice and negligence actions. She was also a judicial intern for the Honorable Marjorie Rendell, U.S. Third Circuit Court of Appeals, and a summer law clerk for the Honorable Juan Sanchez. Ready to get started, Nicole?
I'm ready.
All right. So let's start with this. What led you to get into the field of eDiscovery, and how did that lead to the role you have today as chair and managing member of Cozen O'Connor's ancillary business unit, CoDiscover?
Well, my first job out of law school was as an associate attorney in general commercial litigation group, again, as you mentioned, at a Northeast-based law firm. And that firm really had lean and mean case teams. So I wound up handling my own discovery from RFPs to data ingestion and review. And I frankly found it to be the most exciting and integral part of the litigation because you have that development of strategy to get through documents, that understanding of key documents to support particular claims and defenses, and the potential to find the smoking gun, which doesn't happen nearly as often as we wish. When I left that firm, I joined Cozen as part of their eDiscovery practice group that was formerly known as eDiscovery and Practice Advisory Services, or ePAS. In ePAS and within Cozen, I found some fabulous mentors. They were really committed to advancing not only my eDiscovery knowledge, but also my career. So I quickly distinguished myself as an expert in the field. I just really took to it, and I took on more and more responsibilities within the department. And while we were dealing with ePass, we serviced internal COSIN attorneys. And when COSIN attorneys were unfortunately required to use an outside vendor, I listened to their complaints of either slow response times or this one size fits all approach. And it made me wonder if other outside attorneys had similar experiences and would want to partner with an e-discovery vendor that was maybe a smaller boutique. So ePass slowly, but then kind of quickly was spun out into a wholly owned subsidiary of Cozen O'Connor, so we could work with outside law firms and provide our vendor and managed review services externally.
So a lot of the e-discovery disputes that I cover stem from the failure of the parties to cooperate in discovery. As someone who participates in 26F conferences and negotiates agreements and stipulations, how do you approach those situations to balance advocacy for your clients with the need to cooperate with opposing parties in discovery?
Well, I think it's really important to approach situations practically, and that's why I wanted to include the word practical in the subtitle of the book. Oftentimes, attorneys will get caught up in zealous advocacy for their clients, which is admirable. But if that advocacy is really impeding moving the litigation along, it's not focused necessarily on fighting for something that is truly important, then time and money is wasted. So, for example, I often see fights, as I'm sure you do too, about metadata exchanges. So, metadata is certainly important for understanding documents, origin, etc. Of course, you want to exchange metadata with your productions, but if the hangup in finalizing an ESI protocol is that one party wants production of, say, the last accessed date, but another party is fighting against its production, perhaps both parties need to weigh how important that is for production. Is the date of last access of the document critical in proving or defending the case? Both parties truly need to evaluate the answer to that question and then proceed in a manner that does not waste the client's time or money on what is essentially not important to the case.
Sure, pick your battles, right? Absolutely. Yeah, couldn't agree more. Let's talk about your recently released book. What inspired you to write and publish a book on best practices for e-discovery?
Well, I wanted to demystify the world of e-discovery, especially for young associates and individuals who do not have an e-discovery group readily available in their firm or maybe have limited resources. By walking through the various steps of the EDRM, the book hopefully provides a step-by-step guide on how to approach discovery in a case, again, in a practical manner, from collection of that data to ultimate review and production. It also provides some tips and tricks on how to navigate some trickier steps of the EDRM so anyone can really go into a Rule 26F conference and at least know the basics to negotiate and advocate from a place of knowledge. There's often a disconnect between technology and legalese, and hopefully this book will serve as a translation between the two.
Yeah, absolutely. And I think it's really nicely structured too, with the first three chapters really kind of giving the background of things like the rules and the EDRM model, and then of course talking about information governance and what have you, and the remaining the last six chapters really walking through the EDRM, very logically oriented, and definitely I think will be very informative to a lot of folks. And so, of course, that book, I mean, the book does walk through readers through the full life cycle of e-discovery. So, what phase or phases do you find most often overlooked or underestimated?
Preservation. Most of the cases I read and that I know you write about are about spoliation. Spoliation begins at the preservation stage, understanding when our obligation to preserve data arises. So, again, news alert, it's not when you receive the filing of the lawsuit, it's at the anticipation of litigation. And also understanding technology enough to know either how to turn off automatic deletion or who to talk to suspend that automatic deletion. So staying on top of new technologies and understanding retention periods of those new technologies, it's a full-time job. Obviously, we would be out of jobs if it weren't. But data preservation starts to become especially tricky when you're dealing with, say, employees of corporate clients who have personal cell phones governed by a BYOD policy. Thank you, COVID, for the rise of that. So we need to really make considerations for that and making sure data is preserved so that clients, and especially corporate clients, do not become the object of a case devastating sanction. But the flip side of that, too, is that you cannot just save everything for all time just in case you get sued. So knowing the balance between preservation, but also balancing that with really important information governance policies and procedures. I think oftentimes information governance is overlooked on the EDRM. So in the age of rampant data breaches, the more data we have, the more vulnerable we are, the more increased time and cost associated with ameliorating a data breach. It's something to just keep in mind. So again, that delicate balance of, yes, we have obligations to preserve data in the event of litigation, but we also need to know just on the daily basis of how to balance that with appropriate information governance policies and procedures that allow us to defensively delete data as well.
Yeah, absolutely. I say all the time, InfoGov is the foundation, not just of eDiscovery, but really everything, cyber, data privacy, AI, you name it. Effective information governance is really key to making all those other processes more streamlined and avoiding the types of problems you can have in preservation and spoliation. Um, so what are some of the common mistakes you see legal teams make in the e-discovery process that you address in the book?
Oftentimes, I see a lot of incomplete data collections. Pretty much, at least in my experience, often precipitated by self-collection. So I understand individual clients, especially as e-discovery costs get larger and larger, that individual clients, corporate clients, they may want to collect and cull data on their own to save costs. However, most self-collections that we receive are often incomplete. There's inherent bias. There's often a lack of technological know-how. There's also this element of indefensibility that comes with self-collection. So really, I often advise clients to have either an expert in their company that is really familiar with their IT in order to do appropriate collections or to engage an e-discovery vendor to complete the collections.
Couldn't agree more. So let's shift gears here for a moment. What are the e-discovery challenges that keep you up at night, and how do you look to mitigate those challenges with your clients?
I often think about workflows and ultimately how to get through large document swaths efficiently to meet court deadlines, but more importantly, to meet the client's budget without producing privileged, sensitive, or irrelevant material. I think there's still this fear of when you hit send on a production, you have done all the QC and you're still thinking, mm, I don't want anything sensitive or privileged in that production. I dream about creative workflows and novel workflows to accomplish, producing in efficient, effective manner. And in the next edition of this book, which I'm already dreaming about, I plan to address the use of at least generative AI to accomplish this. I think right now, yes, it's out there. I'm demoing products, as I'm sure you are, on the daily, in order to make things a bit more efficient and effective. But for now, I've focused, especially in the book, on predictive coding and traditional tar, and because generative AI is still, again, very much in flux. There are new tools. Technology-assisted review workflows help mitigate the challenge of getting through large data swaths quickly, and I mitigate the challenge of an inadvertent disclosure through robust QC with individuals who are really knowledgeable about the matter. I mean, I think it comes down to, again, understanding novel and workflows that will help efficient and effective productions, but also partnering and having a really good team and a good workflow surrounding your QC before productions go out the door.
Yeah, I mean, people process technology, technology assisted review really leverages all of that. So, no doubt about it. As a leader in both your firm's women's initiative, the Philadelphia chapter of Women in eDiscovery, and the Philadelphia Bar Association's Wellness and Quality of Life Committee, how are you leveraging those leadership roles to mentor the next generation of women legal and eDiscovery professionals?
Well, through these positions, I'm able to at least spread the word about the field of e-discovery so that the next generations, especially of female attorneys, understand that it is indeed a practice area. When I left law school, I knew about discovery, but I did not know that a whole career could really be steeped simply in the EDRM. So I think, awareness, using the platforms that I have in order to just make individuals aware that this is really available as a career. Personally, I always appreciated and embraced technology. So knowing that this is a field of practice for a female who is technologically minded and a burgeoning field at that is really exciting. And I'm always excited to share those experiences with young attorneys, especially through my leadership positions. I've had some fabulous mentors in my life, and I like to pay it forward, especially to young female attorneys, to show them not only best practices and work with them on how to excel as an e-discovery attorney, but really just to be empowered in the practice area. There are often times that I am the only female on a call filled with male technologists and attorneys, but I want women that I mentor to be confident in their abilities so that their voices are heard.
Sure, absolutely. And it's admirable what you're doing. And obviously, Women in eDiscovery as an overall organization, they've just done some tremendous things for our industry. Last question that I always ask. What else would you like for our readers to know about what you and CoDiscover are working on?
We are currently embarking on an exciting time of expansion of the business, but also expansion of workflows. So right now we are continuously growing, managing more external law firm data, offering managed review services for other law firms, and providing information governance to companies at an increasingly growing rate. But we are also, as I had mentioned, sitting on this precipice of amazing generative AI solutions. So we are currently not only demoing, but onboarding a lot of different generative AI solutions and really wrapping our hands around them and developing novel workflows around those applications so that we can continuously stay ahead of the curve when it comes to technology and giving our clients the most efficient and effective e-discovery solutions.
Great. All right. Well, this was a terrific interview. I want to thank my guest, Nicole Marie Gill of CoDiscover. Thanks, Nicole.
Thank you so much, Doug.
And I want to thank all of you for tuning in to another edition of eDiscovery Today's Thought Leader Interview Series. See you next time on the eDiscovery Today video network. Goodbye.